And Trevor, why don't you come online? And are we recording, Don? I'm just checking.
Of course we are, Pete.
Oh, of course we are.
As we do. Don didn't remember always in the past. So again, financial estate literacy. This is, I lost it again. It's your estate 2022. And this is week 6, which is the final week. It used to be 8 weeks. We've consolidated and got rid of some duplication. And so this is week 6, which is going to be estate administration. Now that we've talked about all the pieces and all of these things, now we talk about, okay, now what am I going to do when it needs to be handled? And I will say the material is on the website, iyme.org. Yes, thank you. And all the material for all the classes are there. The videos are there. In fact, as of yesterday's video, it's already up in terms of It's Your Money for week 6. Trevor has gotten tired. He wants to go look at the videos until anyway, so that's what we are. So Pete, do you want to do any, and incidentally, I will monitor your Q&A. I do not monitor your chat. Q&A, the thing that starts with a Q and A, not the one that says that other word that we don't use. So I will monitor those and stop them if possible with questions, and we'll get her going. Thank you very much.
All right. Thank you, Don.
Thank you.
Welcome, Trevor. I appreciate you come on today. And I see you have professional fiduciary services in the background. For full disclosure, we both are part of professional fiduciaries, and our DBA or our name is Professional Fiduciary Services. But we're here not to gain your business. We're here to educate you because we are involved in estate administration on a 24/7 basis. And so let's talk a little bit about, Trevor, your Ask First form is on the website, but what's your educational background?
Thank you, Pete. Yeah, my educational background, I have a master's from Georgetown University, and I have a degree from UC Berkeley in economics.
Okay, and your master's in from Georgetown is in what area?
It was the Master's of Foreign Service,
and
so it was international diplomacy.
International diplomacy, yeah. Which leads me to believe that's a perfect background to be a trustee. Why do you think I say that?
Well, it's kind of like, when someone passes away and you got to sit there at the kitchen table with all the children. It is like you are at the United Nations.
Yes. And speaking of, we just had cats. Sometimes families are like herding cats to do what you need to have them done.
Yeah, but they have different, they may not get along very well. That may be one of the reasons why you're there. There may be some other issues, maybe some substance abuse issues. There's a lot of empathy that comes with this job, but there's also a lot of diplomacy. Now, they may not be nations, but they have their own agendas a lot of the time.
And then is there a license required to be a professional fiduciary?
Yes, there is. And we do have some slides on that, but
and you're licensed?
Yes, I'm licensed, and you should, if you ever engage with one, make sure that if they say they're licensed, that you look them up on the.
And where do they look them up?
On the Professional Fiduciary Bureau's website, and there is a search licensees function that you can follow, and it can filter to whatever you want to look for.
Okay. How do you charge for your services?
Well, as a professional fiduciary, it kind of depends on the position that I'm serving in. But tonight we're going to talk about trust and estate administration. So if I come onto a case when someone's incapacitated, I charge an hourly fee for most of the fiduciary positions. When I come onto the case in a irrevocable trust administration, where I am managing a separate entity that's different than the decedent, then I charge a management fee of 1% that scales down based on the size of your estate. And it's prorated from date of death to final distribution.
Okay. And are you affiliated with anyone who's selling any kind of insurance, financial, or any kind of product that you get a commission on?
No, but I do use a lot of insurance agents and things to protect. Like we're going to talk about that tonight. So I do have a vetted network of professionals that I use for many different services that I may employ, but I don't get any kickbacks or any guaranteed business from them.
Okay, let's go through the program. By the way, my Ask First form is also on the website. My fee schedule is also on the website. The cost of dying is approximately, as a rule of thumb, approximately 5% of your net worth. So professional fiduciary fees are just part of that. And we'll go through some of those issues as we go through the presentation. You want to expand that outline there?
Okay, you guys can't see my.
I can see all the slides on the side. I think you just hit the. I'm not sure. I think
Can
Don
you see the
would.
presentation now?
Yeah, there
There
you
you
go.
go.
You got it.
All right. Well, I was trying to see if I could share the website, but I can show that later.
Okay.
But yeah, thank you. And Pete is he's he knows this stuff more than I do. So he's going to be co-presenting, but also hosting as well. And that's why his name is up there too. So not that he doesn't do that anyway, but he's formally invited to do that in this presentation. So first of all, I want to put it out there that most of you are going to be using a family member for these fiduciary positions in trust and estate administration. So the angle of the presentation is really to get you the information so you can inform them, the family member that you're going to choose very carefully, who's going to, what the job is, and especially to your particular case. Or maybe your parents are still alive. You're going to have to be this successor trustee or power of attorney or something. Then
Why don't you bring up that first slide that you have?
Yeah.
There you go.
It is. Okay. So the fiduciary positions in an estate plan. We throw this word fiduciary around a lot. I know in the It's Your Money series, there's a fiduciary standard of care we want with your financial advisor. Your attorney has a fiduciary standard of care. Your CPA has a fiduciary standard of care. But what we're talking about now is an actual person that is serving as a fiduciary for you, the person. It's almost like when someone dies, there's this interim person that takes your place to finalize everything, and then you live on as a new tax ID number. I'm just kidding.
Well, the other thing too is that when you step in for somebody who suffers from an incapacity, go back to the other slide for a second.
Yeah.
Which documents are you using more likely?
Yeah, so in the incapacity positions, those are the first two documents there, the durable power of attorney, the advanced healthcare directive. However, if you have assets titled in your living trust, what most of you will, your successor trustee will step in depending on the incapacity clauses and what they say as your successor trustee of your living trust when you're still alive. And as you know, those are the agents in the fiduciary positions. And then on the right, remember, you have to choose these. You cannot create an estate plan without giving your attorney some names. So we recommend 2 to 3 people in succession, not as and I know you've talked about that. But
yeah, well, one of the things that we recommend as well is that if you name somebody in the position, most attorneys just include 1 to 3 different individuals, but they don't include, they don't give the power of the trustee, for example, to appoint a successor trustee. We recommend that highly. It's to give your document flexibility, because you just don't know who's going to be there by the time you're 90 or 100 years old to step in.
Yes, it's true. And we're trying to educate attorneys all the time to do that. And it also keeps it out of the courts. and it keeps all the expenses down if you do something like that. On the bottom is in red. That is not a document. That is what you may find yourself if you do not have an estate plan, is in a conservatorship. And there's two types: conservatorship of the person, and that would handle the healthcare directive part, and then the conservator of the estate, which would handle your finances.
Yeah. So
don't
this
wanna-
is all about money. And so you have to have the proper documentation, even as a family member or even as a spouse, that you have the legal authority to handle somebody else's money and assets. And it's nobody, no bank, no brokerage firm allows you to just handle somebody else's stuff without having the proper documentation.
Pete, can I ask you, we're going to be talking about fiduciaries, and a corporate trust company can be a fiduciary too. Will they serve in all these fiduciary positions?
No, first of all, no corporation will serve as your agent for your healthcare. Few will do the durable power of attorney. Almost all of them will do the trusteeship because that's managing the assets. And are we going to go into the fees of those particular corporations?
I do have a fee schedule.
Okay.
We can do that. Yeah, we have a slide on fees, so we'll talk about that then. So back to what I am, just so I can just sort of tee it up for you. What I do, I'm licensed by the state of California in the Department of Consumer Affairs as a professional fiduciary. These are what we'd have to do to get that if you are from a non-exempt profession. There's some professions that already have a fiduciary standard of care for you, but I still recommend you would use a licensed professional fiduciary if you were going to do this. We get background checks, examinations, qualifications. Every year we have to disclose all of our assets under fiduciary management, and that includes the values of real estate or businesses that have fiduciary management over to the state of California to keep our license active. And we have to, on our birthday, they give us a $700 bill that we pay renew our fee. If you want to find out more about professional fiduciaries, I recommend going to the website up top at the government website. But then there's also a professional association called PFAC, and they have a lot of resources for consumers to learn about what a fiduciary can do for you and whether it's a good choice for your family.
Yeah, and I would interview a minimum of 3 people. If you're thinking about hiring a professional or even a corporation, and I would think twice about hiring a friend to do this. And
why is that, Pete? Because then they have to deal with your family, right?
That's right. And they may be trustworthy, but they just have not done this before, and it puts them in a very awkward situation.
Yeah, and often your friends are of similar age.
Yeah.
So they may not want to do it at that age.
So what services do you provide?
So these are services that you and I provide, but also
your family member
will have to survive. So you have to think about if they can do these things. So manage your assets, both financial and real properties. A lot of people become incapacitated with like rental properties or things like that. You got to collect rents and all that and manage the assets. Maintain all the records and bookkeepings, and there's new legislation where you may be having to account to remainder beneficiaries if you become incapacitated, if you're serving as a fiduciary. Communicate with all the beneficiaries. They have to do that very well, I think.
I would put a big star behind that. Communicate with the beneficiaries. So if you're picking a family member who doesn't get along with the rest of the family, they're going to have a major problem.
Yeah.
In fact, I would say that the vast majority of cases in the probate court is because the beneficiaries don't get along with one another.
Oh yeah, and that affects communication and accounting, because one demands it from the other. The other one's, and it's full of it. So, managing all this, getting rid of real property, just all the distributions that you're going to make from your estate. And then I've had to make funeral arrangements for people I've never met before. I don't know if you've had.
Yes, just
Yeah.
made one yesterday.
Yeah. So, I mean, those things. And then this is really, I think, once you pass away, things work out and we can do it. But when you're still alive and we will oversee your care management plan, I think that's a very serious position. It's something that you're preserving the estate for, and the wealth for the next generation, but you're also taking care of the principal. So you're managing a care manager.
It takes time too. It takes a lot of time caring for someone. And so one of the good questions that you always want to ask for a family member is, can you take the time? If I need you, can you step away from your work or step away from your children? Finding board and cares, taking you to the doctor, hiring caregivers. It takes time to do.
It does, and a lot of time. And the communications too, when you're communicating this back to everybody. I mean, you could be on the phone for an hour to each person talking. So it's very, there's a lot of work, more work than you may think. Some of the benefits of using a neutral third party like a professional, and I'll go through this quickly, but there's no emotional attachment to the money or property, which often comes with a family home, an adult beneficiary and so forth. We have a lot of experience because we do this all day, every day. Therefore, we have a flexible and vetted network. So, often with a corporate trust company, they'll bring everything in-house, all the services, where if you've had a long-time CPA that everyone knows and loves, we can still use them. Or, even a financial, if the advisor, if they're a fee only, or, maybe there's been a good care manager that checks out. We're flexible in that. So one thing we'll talk a lot about tonight is fiduciary liability. And sometimes when you put fiduciary liability and responsibility with a beneficiary that's also a trustee, conflicts can emerge. And part of this presentation tonight will try to help us avoid that, because often that'll be the case. If you've named a family member trustee, most likely they're a beneficiary, I assume. Do they get compensated? What do they get? What's a fair and reasonable for that? Charge for that. And we know the probate codes. So that's one thing that even your family member has to know, the probate codes that govern us as fiduciaries. And that's really important. And then we, of course, serve in all fiduciary positions. And there's an error on there. It says your beneficiaries, I should say, are less likely to fight. Sorry about that. But just having a neutral third party that can kind of manage all the angst and issues between the beneficiaries.
By the way, just reiterate up front, this session is about helping your family member be the fiduciary. But in some cases, it's just best to go outside, and each and every family is a little different. So you just need to be objective in your own, when you're choosing the people in this particular position, you need to look at them objectively.
Yes. And it's more just about being realistic about your family and not worried that you're going to offend somebody because you've made a realistic choice based on the.
Well, as one attorney said, if pick an outside professional and that'll unite the family because they'll all dislike the person.
Yeah, they'll hate you now. Okay, so Pete, I don't know if you'd want to bring up the fee schedules or if you'd want to just talk about
people can look them up and they're on their website, but
because I have the corporate one too.
Yeah.
But we can just talk about like these are some of the fees and how they're, maybe you want to speak to this
Yeah,
slide.
when you hire a professional, it's somewhere between 1% and 2% annually. So if you have $1 million estate of trust assets, when you hire them, it'll run approximately 1% per year. If you upon death, in the year of the death, it's likely 2% of your net worth, total cost. But you can look at the particulars on our website. If you hire a corporation, like a trust company, you're looking at somewhere between 2 to 4% per year. Much more difficult to find out exactly how they charge. They have an extensive fee schedule. On our website, we have a sample of Union Trust Company Bank, so you can take a look at their fee schedule to see what you're going to be paying. If you hire your own family member, the question becomes: are you wanting to do that? Are you wanting them to do that at no charge, or do you want them to be paid? So you need to talk about that as well, because there's a lot of work involved in administrating a estate. So if you hire a person in a family member, we suggest somewhere between 0.5% to 1% of your estate value. Make sure you tell your other children that you want the one child that you chose, that you want them to be paid. This is not an easy job. Let's say many people hire their CPA or their attorney to be in the position. Much more expensive. A CPA will charge you on an hourly rate, their regular hourly rate. An attorney will charge you on their hourly rate. So the nice thing about hiring a professional is that we don't need to see as many professionals and only bring them in when absolutely necessary. So we kind of reduce those overall fees as well. Let's go to, if you don't have any of these documents.
Yeah, you could compare the cost of if you just had a will or you died intestate. The difference between, doing this on a private trust administration.
Yeah.
So this is actually in the statute, our California probate code. So if you have $1 million estate, it's about $46,000 and 3% by statute, and this is gross. So if you have a mortgage or something on property, it's the gross value, and that determines the attorney's fees and the executor fees. And then of course there's always costs when you're dealing with the court. So here's another chart too. It kind of breaks it down a little, but if you have a smaller than $1 million estate, but it's still quite a lot of money compared to, let's say, $1,000 to $2,000 preparing an estate plan with an attorney up front, and then 1% to 2% of a trust administration.
When you're hiring a professional fiduciary, the fees vary amongst the professionals, depending on their experience. There is no one set fee among professionals. The same goes for trust companies. The same goes for attorneys and CPAs.
So let's make sure we do our terminology correctly. So Pete, Trevor, whoever the professional fiduciary is that I hire, or a family member, are they acting then, I've passed away, as the executor? Or is that someone different?
If you're serving just as under the will document, then you are named as the executor or as a personal administrator. And you have fiduciary duties based on the probate code as well. If you're serving under the trust, then you're serving as a successor trustee, And although you're not in court, you're still controlled by the probate code.
But effectively, if I'm the successor trustee for someone who has passed away and had a trust, I'm the executor effectively.
No,
No.
only
Who's
if
the executor?
There's no executor. You nominate an executor in your will. You don't become executor until the court blesses it in a probate, formal probate administration.
So,
So you may
an
not
executor
even
is
use
only for a will.
Correct.
In a trust, it would be a successor trustee, not an
Correct.
executor, because that doesn't exist. That title doesn't exist.
Exactly.
Yeah, you're nominated. You're most likely, if you have a trust, you have a pour over will, and your executor is the same person. But if for some reason we had to probate that pour over will, then that you would assume that position as executor and pour over that asset.
But it's a great question, because let's say the person is alive and you go to the bank and you find out that the bank checking account is just in the person's name. What hat does the professional fiduciary have to wear, Trevor, in order to access that account?
Well, you have to use. Okay, so it's in their own name. There's no payable on death beneficiaries, I assume.
They're still alive.
They're still alive. Okay, well, no, then I would need a power of attorney document.
Yeah.
Yeah, and I hope the bank will accept it.
Yeah.
That sort of situation.
Yeah. And we talked a little bit about that in the second session. The durable power of attorney becomes vital in that circumstance. And you want to make sure that your bank institution or brokerage firm or insurance company accepts your durable power of attorney.
That is so true, Pete. So true. Okay, so what I want to talk about a little bit is, and then we'll get into some of the duties. About if you have a living trust, about 99.9% of the time, that trust is the tax ID of that trust is your social security number. It's basically you. You are the grantor. You made that trust. You are the trustee. You're controlling the assets of the trust for you as the beneficiary. Now, you may have done it with a spouse, and you both are, but that's alive and kicking. You guys are. That's what happens most of your life. Now, when you become incapacitated, let's say you're the surviving spouse and you become incapacitated, you're still the grantor. That trust is still there to protect you and your assets. You're still the beneficiary of that, but someone has to step in, your successor trustee, and manage those assets for your benefit. You're still the beneficiary. You got to make sure whoever that is will do it for your benefit. And then when you pass away, you're still the grantor. That's your trust, but the beneficiary now pivots to whatever in the dispositive provisions of your trust. But that successor trustee who may have stepped in during incapacity will handle whatever your trust says, and their loyalty is to that document. Okay, but Pete, remember, while we're in the drafting stages and planning all this, why is it so important, for us to choose the right successor trustee while we still have capacity and we know what we're doing?
Well, this, from my point of view, this is the most important part about estate planning is to protect yourself, that you have somebody there that will take care of you in the event of some sort of incapacity. And incapacity could be cognitive, it can be a stroke, it could be Parkinson's, it could be a heart attack, variety of different reasons, but you're still alive. And so you need help to take care of you, where you live, pay your bills, take you to your medical appointments, control your investments, prepare your income tax returns, communicate with the rest of the family, the status quo. And what happens a lot of times is that if somebody suffers from some more incapacity, a family member steps in and sometimes the family member gets paid, sometimes they're not. it becomes very unclear and it causes a rift many times in the family. So you need to discuss this your next Thanksgiving. The turkey is dead and we will be as well. Talk about this stuff. It's really, really important. And if family members are not getting along with each other, it becomes very difficult to do the duties of a trustee. Yes, Don.
So just so we're clear, we're clear on this. So I'm gonna have the person pass away. So if someone passes away intestate, they do not have a will, they don't have a trust. Okay.
Uh-huh.
So we're gonna go into probate and we're gonna be intestate. Now, how is someone going to be appointed as the?
What happens is that a family member nominates an individual, and that nomination goes to in front of a judge.
Okay.
And that judge then approves that person if they're 18 and over, if they have sufficient assets to have a bond, chooses that individual. Now, every family can nominate someone. So, every family member can hire an attorney. So it could start off really on a poor foot.
So in the best of situations, I'm the only one who puts somebody in. How long is it going to take a judge to say, yes, you are one?
Well,
then it goes downhill from there.
Yeah, through the pandemic.
Hearing 6 months to 9 months before you know who's going to be the.
Yeah.
And that isn't how long it's in probate. That's the beginning of it.
Yes.
Because you could be easily 18 to 24 months in Orange County before that clears out, but you could possibly be 6 months into this thing.
Yeah. And right now here in Orange County, many of the probate staff are still working from home.
Yeah.
So it's just an unusual time right now. You need your documents. Especially for incapacity.
Yeah. Just to kind of, if you die intestate, you're not going to have an executor. That's not going to be the title. Executor is specific to a will that actually is a testate document. If you get nominated during an intestate probate, they call it a personal representative or something like that. So just for the vocabulary, just so you know.
Yeah. But all of the trustee duties that you see on the screen right now, whether you are an executor or whether you are a trustee, all of these issues you have to abide by. And what does fiduciary mean just in general layman terms?
It means you have to do what's in the best interest of the person you're the fiduciary for, even if they're dead. I mean, and so it's a higher standard of care than someone who's not a fiduciary, and so the courts.
I think you can explain it. If somebody accuses Trevor of malfeasance for some reason or another, just the accusation, he has to show, the burden is on Trevor to show that he's done it correctly.
Yeah. So like Pete said, an example, like if someone steals something from me, I have to prove that they stole it. The burden of proof's on me. But if someone accuses
under normal liability.
Yeah, under normal liability. But under fiduciary liability, if someone accuses me of breaching one of these, I have to prove that I didn't do it.
Yeah.
Whether that's with a proper accounting or whether that's with, whatever it may be, I have to prove, and the beneficiaries have a lot of rights to get information and so forth. But
that's why a lot of times corporations will not serve because of the potential liability.
Yeah. And they tend to, if your intent is you want to keep real estate or some other asset in your trust, they most likely won't serve in the sense where they have corporate policies that say they have to have liquidate and have X amount percentage of their trust portfolio in,
Yeah. Well, the first two duties that you have on the list here is that the trust is the Bible is another way to put it.
Yes. Yeah. And if you guys, if we talk about something and there's something that, piques your interest and you want to learn more about it, I just recommend Googling probate code, whatever it is, and then read about it. There'll be articles by attorneys that write about it or whatever. But, we've extracted, the probate code looks like a phone book. And if you have insomnia, I recommend you open it up and start reading. But we've extracted the duties that are specific to sort of being a fiduciary of a trust or an estate. Now, in estate administration, the probate we just talked, that's in a trust administration, they're basically doing the same thing, except in the estate administration, it's managed by the court, and there's roadblocks sort of and checkpoints where they got to make sure everything's done right. In a trust administration,
Don is holding up the probate code.
Oh yeah, there it is. Don has a copy of it.
This is section I, 146 page.
Yeah.
This thing is a phone book, and this isn't even the current one. This is a couple years old.
And by the way, that's full of duties.
Yeah,
and so
it's crazy. No, there's a lot, and that's what the attorneys use to
sue you,
fight over stuff. But so if you know these codes, or your successor trustee knows these codes, it helps them protect themselves, because remember, they have a fiduciary liability. So yeah, the first two is it's that sort of like, you haven't updated your trust in 15 years and it says this, but then before mom died, you're like, oh, we talked about that. We're not going to sell the home, or we're not going to, do this or that. But Pete, if it says it in black and white in the irrevocable trust now, what are you bound to?
We're bound to the terms of the trust. Now, if all the beneficiaries agreed that it should be different, we can go to the court and ask the court to change it, but we can't change it on our own. So it amazes me how many people don't read the trust. They just assume that everything goes equally to all the family members and just start proceeding from there. You just can't do it. You got to read the terms of the trust. What does duty to account mean, Trevor?
Well, this is one of the most breached duties, because your successor trustee may or may not be very good with keeping records and keeping everything separate and identified and so forth. So often in your trust document, there'll be a clause that says the successor trustee at least annually has to do an accounting to the other beneficiaries of the trust. Now, also, when you do final distribution, you most likely are going to do some sort of an accounting that they can approve and sign off on, that everything's okay.
Yeah.
To also protect yourself.
Beneficiaries want to know every dime that has come into the estate or the trust, and every dime that goes out from that trust. And so
you do it by the dimes.
Yeah, again, so who are you going to pick? An artist to be your executor or trustee? No, you're going to pick somebody in the family who's somewhat anal, that is dots the I's, crosses the T's, that's very particular about accounting, because this is the area that most beneficiaries are interested in, is how was the money spent and to whom did it go to? Confidentiality, what does that mean?
Well, you're not. I guess what that means is there's certain people that are entitled to the trust, and there's certain people that are not. And if you're the the trustee, you have to make sure that you respect their wishes with that.
What I see most is that trustee hires a real estate person to sell the house. And that real estate person is a friend of one of the beneficiaries. And that friend gets more information than the trustee. That's a breach of confidentiality. remember the trustee will hire an attorney, which is highly recommended, but that attorney just represents the trustee, not the other beneficiaries.
And they represent him as trustee of the trust,
Yes.
not as a beneficiary of the trust, even if they're the same person. That's very important.
Can you hire somebody and, like, say, for example, I hire somebody at Merrill Lynch and Merrill Lynch kind of screws up the investments. Am I liable as a trustee for that?
Yes, sir. Because you have a duty to prudently monitor. I mean, yeah, you have to prudently, first of all, prudently delegate, and then you have to monitor your delegation. And we have slides on that. We'll talk a little bit more about. But yeah, anybody you hire, a property manager, real estate agent, CPA, you do have a fiduciary responsibility and liability if they mess up. Now, there's ways to protect yourself if you've done everything right, but you're still there and exposed to that. So that's why it's very important to make sure you hire the right people. And often what happens is, yeah, you get you hire the son-in-law to fix up the kitchen, or the you may have, I mean, who doesn't know a real estate agent, right? So there might be a real estate agent in the family, but they haven't done they haven't sold properties that were, let's say, an irrevocable trust that had a trustee selling it, and they may not know what they're doing in that sense. So that all goes back to the trustee, who they delegated.
What does loyalty mean?
Well, I take it as loyalty to the document and what it says, but also loyalty to the beneficiaries, um, even if one of them is not a nice person. You have to have impartiality and loyalty to that. What do you take it as?
Well, it's kind of like the common area that I see is that mom just purchased a new car and it's in the garage. Very low mileage on it. And the trustee, one of the sons, is named as the trustee. And he...
I just had that case.
I don't know why that's so common. And the son, who is the trustee, takes ownership of the car.
Basically they steal the car.
We don't want to use the word steal.
Yeah.
But the son just did a self-dealing. That's a violation duty of loyalty. In how he should have done it is that offered that car at a fair market price to all the beneficiaries that he is willing to pay for it himself. And that's how he gets around if he wanted the car. But there's a duty of loyalty. And the loyalty means is that everybody else's interest comes first before their own. And that kind of goes into the duty of impartiality.
Yeah, exactly.
Even if you don't like your sister or brother, you got to treat them equally.
You got to treat them equally. And you got to make sure if you're nominating somebody that even if they're, that they can do that with the other people. Be realistic about that. But,
what is duty to take control and preserve?
Well, that's a very important duty. Often when someone passes away, there's a series of steps that takes. I mean, the first thing you do is get a death certificate, and then you can start what's called marshaling the financial assets. There's also you got to take control of any real property like homes or rental properties, and make sure everything is on the up and up with those. And
let's say if I had to come across, I'm the trustee, and there's one of the family members living in the home. What happens?
Well, if the trust doesn't specifically stipulate that situation and what to do, then there's a very strong chance where we'd have to do an eviction if there's multiple beneficiaries and so forth. And that's really difficult, and especially if you have to have let's say a sibling trustee evict another sibling. from the family home or something like that. That's a situation that really needs, I think, should be managed in your estate plan even before it happens, if possible.
Yeah. That needs to be talked about. What if I own my entire stock portfolio? I worked for Apple Computer, and I have just the only asset I have in the market is Apple stock. What do what do I do if I become the trustee?
Well, that's an interesting question, Pete, because I know what you want me to say. And most likely, I mean, what you should do is there's a duty to diversify, and you probably should liquidate, get that step up in cost basis. And then when you do the distribution, you can, they can buy the stock back or whatever they want. Often, though, I mean, you do get these situations where this was grandpa's Chevron stock and, you want to keep it in. And sometimes, if those situations arise and all the beneficiaries are sort of feeling that way, you can make the gift in kind.
Yeah, but if it was grandpa's Enron stock, you should have diversified.
That's true. That's a good,
just as a point.
Good point. That's a good point.
Yeah.
That's what can happen. And that's the risk you take if you do something like that.
Right.
Sure.
But if it needs to be stated in the trust, that's the more important. If you want,
right.
It needs to be stated in the trust that you want this asset to be given in kind and not to be sold.
Yeah. Or I've seen clauses in trust, Pete, where they kind of strip back that duty to diversify, meaning my trustee doesn't have to keep my whatever.
Yeah. Duty to make trust property productive. Does that mean that I invested in Enron?
Well, there's a couple things. Unless you're going to do a distribution trust where you're just liquidating, distributing to the beneficiaries. If you're the trustee of, let's say, a subtrust or a special needs trust or someone else's irrevocable trust, whatever's in that trust, you have a duty to make productive. So you can't just put it in a cash savings. Well, I guess you can't put it in just a checking account sitting there. There's this duty that makes you keep it productive. Same with real property. You can't just leave a property vacant and not try to make it productive. Do you have anything to say to that?
Yeah, well, it's usually a family member is living in the house and not paying rent.
Well, yeah, that's another thing too. Yeah,
I've had conversations. We can rent this house out and get X amount, and we have to talk to one of the beneficiaries living in the house and say, I have a duty to make this property productive, and so you need to move out or pay rent.
I slapped the probate code too. Hey, listen, according to probate code 1607, I have to make this property productive, and it's true. It actually that forces the trustee to actually have to do that eviction, even if they don't want to. And it's sad because often the person living in the house may have been taking care of mom for 2 years or something, and now all of a sudden the trustees put in a position where they have to evict and all out of the gates.
And that's why these duties, it's really important to kind of discuss them so that most families, by the way, the majority of families work it out. There's no problem. This is not a fear session. But let's say here in Orange County, we have 3 million people. 20%. That's a lot of problems, a lot of people. So you just need to be realistic and figure out if your family can figure it out amongst themselves, or do they need somebody outside and just kind of help them out. Let's go to the next slide.
Okay. So one of this slide, we didn't really talk about it much, duty to furnish information. Now, I'm not going to go through every line of this, but this is a very important probate code in our state. Okay. And remember, all these are statutory. So state by state may be different how they do things. A lot of it's the same general thing, but how they do it might be different. in California, when a trust becomes irrevocable, the trustee of that trust, the successor trustee, has a duty to send out a statutory notice to the beneficiaries. Now, this may be if you're married, it may be on the death of the first spouse. If you have, let's say, an AB trust or an AC trust, which you guys talked about in the trust session. But most of the time, it's when kind of on the death of the surviving spouse, when the trust becomes irrevocable, the successor trustee has to send out, we call it the 120-day notice.
Yeah.
Yeah.
And we don't do much. So figure a timeline. You die. You don't immediately start taking over on the next day. It takes usually anywhere from 20 to 30 days before, you will look at the trust and you look at who the trustee is. The trustee hires an attorney. And then for basically 3 months, we don't do a whole bunch from a point of view of selling assets, because during those 3 months, everybody who's named in the trust and immediate family members can protest the document, can protest who's named as trustee. And so that 120-day notice needs to go out, and not much is done during that period of time. So already we're looking at 4 months before we actually get into the nitty-gritty of the administration.
Yeah, no, and that's true. And that's something that is part of the communications, right, of the successor trustee, because as soon as he finds out or she finds out that's going to be the case, that's when they should be calling the other, hey, this is what's going to happen. There's this 120-day notice coming out. We're not going to be doing much in those days. Just let everybody know, so it doesn't look like you're just sitting there doing nothing.
Yeah.
But
And
wait a minute. Mom died. It's me and my sister, and we agree on everything that's going to happen. Or better yet, it's only me. Why do I have to go through all this crud? Why don't I just say, hey, distribute it, we're done?
well, if it's only you, then you're probably correct. You got nobody to complain about.
Yeah,
But-
I might have creditors. I might have all kinds of other people.
Well, that's true. And if there's a lot of money to be owed, you better then go through the formal process.
So even
Yeah.
if my sister and I agree, now that there's 2 of us now, then if we both agree, do I still have to do all this stuff?
yes,
You're taking a
according to the
risk if you
statute.
don't.
Right. Okay. That's the
You know,
important part.
Yeah, the risk,
It may all work out perfectly.
it may
On the
all
other
work
hand,
out.
Do the documents and just get it done. And therefore you've lessened the risk.
Correct.
There's a lot of risk. I mean, if you use an attorney to do this for you, which is one of the things that we tend to do, because often there's like an error search process or step to it too, just to make sure that we're
You didn't know you had a sister?
well,
That happens sometimes.
Oh, yeah.
no, but also if you have, let's say, if you look at our intestate laws, if your next of kin is not your beneficiary in your trust, they are also entitled to.
If I'm intestate, I don't have a trust.
Yeah.
Well, I mean, I know, but they go to how it goes through.
Oh yeah, the dominoes.
Yeah.
Yeah.
So, but most of the time, your next of kin is a
Okay.
beneficiary.
Yeah.
But if it's not, if you're taking out your kid or you're omitting someone, they still get a.
One of the questions we get often is that will family members be responsible for any debts of the decedent?
Family members will not be specifically responsible, and it's one of the things people have an unreasonable fear about is debt collection of the decedent. It really, as you know, it's one of the last things that we may even pay. In fact, any sort of credit card debt or anything that ends at death. So any contract, therefore, you have a lot of negotiation. You can get that down. to 50
Well,
50
let's go through that again. When you have a credit card, you have a contract with the credit card company. And when you die, that contract ends. And
But I
so
may still have that debt. The estate.
you still
may
have the debt, but
Right.
should no more interest can be charged? And that debt usually is the last, as professionals, that's the last debt that we pay is to the credit card companies.
But to be clear, and Trevor was very specific, as a beneficiary, I don't have the obligation to pay the debt. But the estate may have their obligation.
Yeah,
correct.
Which means net, I don't get as much, but I didn't have to physically pay it. If grandma died and had no more money, that all dies with her. I don't have to pay it, but there may be nothing coming to me.
So if you have a low net worth, get an American Express card and travel.
Yeah. So
we're being recorded, Pete. No, don't do that.
So this particular notice, it says in the code you have, no later than 60 days following the event, but don't get scared if that bleeds over. It's just a sort of a terminant. Now it also goes through what has to be in the notice, and it's interesting because the probate code for the most part is actually quite flexible. It's very rare where they say you have to do this.
Notice is everything.
Yeah, but see how I won't go through this, but see how it says if they have to set out in a separate paragraph in this notice, and they even give you in no less than 10 point. They're actually putting the font size in the probate code. You may not bring action to this contest. So it says there, it says you have to put that in. And then the next one, because I get questions at all this time, they say, well, can't we just waive that so they don't have to do that? Well, it says there right next thing, it says any waiver by the settlor requiring this serving notice to be served is against public policy and shall be void.
Yeah.
So it's that powerful. You can't even take it out of your trust.
And the reason for that is because the person is dead. And so therefore it's very easy to take advantage of the situation. And so therefore notification is absolutely a must.
Yeah. So like if someone doesn't get notified and they were, a beneficiary or should have got notified because they thought the trust was undue influence, there's all kinds of it. It's, if you sell the family home and distribute the assets, the trustee's going to be on the hook for a lot of that stuff.
Besides real estate agents, there are more real estate agents than there are homes for sale. And the barrier to be a real estate agent is quite low. And there's not a family member that knows a real estate agent. The investment world is about the same. The criteria to be an investment advisor is literally a high school education in 18. So that's why when we become trustees, we find fiduciaries liability among the investment advisors. And here is the duties of that investment advisor: to prudently manage, to establish risk and return expectations, to understand the prevailing market, the duty to diversify, all the things that we talked about in the It's Your Money program that probably one of your kids are not aware of, but they need to be.
Yeah. So you can't, if you come in as a fiduciary, and take over as in a fiduciary position, you can't just do whatever you want with the money. It's not your money. So the California legislature has basically baked in this Uniform Prudent Investor Act into our probate code for successor trustees. And so all of these things that you see are there, and even prudently delegate, Pete. Often people just out of simplicity may use a brother-in-law or somebody that's related to them to be the financial advisor. I almost feel like if you do something like that, you're breaching that duty to prudently delegate.
Well, what happens is that people, giving somebody else your money that you don't know, like a third party, it's just a real tough thing for people to do. And so they name somebody that they know, a family member, a cousin, an uncle, etc., who has less knowledge probably than they do. And so, you have to be aware of this stuff. And the trustee is always going to be held liable for who they pick as a professional, from a CPA to an attorney to a financial advisor to a real estate agent to an insurance agent, etc.
Property manager.
Yes.
So much deal. And then the last one we talked about earlier in the presentation, duty to independently monitor the agent's activities. So whoever you hire for all those things we just talked about, there's a code that basically says you have a duty to monitor them.
Yeah.
And
again, 80% of the time, the family members get along, they communicate well, they figure out what to do. So there's nobody that was really complaining. But when you have a complaint, that's when all these issues come up.
Yeah. So, but one of the things is, I think also, Pete, it can go the other way where people don't delegate. They try to do everything themselves. And I don't think the code really wants us to do that either. It just gives us some.
Well, you're held to that. It's under B. The agent has a duty to exercise reasonable care to comply with the terms of the delegation, and also to be reasonable. He or she has to be reasonable at the time that they're making those decisions.
Yeah.
Of a prudent person.
Of a prudent person. And that prudent person could be a midwife. That prudent person could be a school teacher. That prudent person could be a CPA. It's very flexible, but it's not gonna. What I'm saying is, if you are a midwife and a trustee, you can hire people to and prudently delegate it, and then just be on top of things and still be fine.
Just one of the things too is that what happens if a family member steps in during lifetime and they're the beneficiary as well. They try to save money because they know that at the end they're going to get the money for the individual. And sometimes that's a conflict. And so they don't spend enough on getting expertise for the person because they think that way they'll get more money at the end. Yes, Don.
So with some of these notices that we're talking about here, can't I just put a notice in the newspaper that mom died?
Nope.
Isn't that a good notice?
Nope. You have to send out every creditor that you know of. You have to send a notice out
and also to children.
Also to children.
What if I excluded a child? Do you still have to tell them?
Yes.
Dang right. Because there's your potential litigation.
Correct.
If they're named, I mean, I just went through this with my sister as an example. A simple spousal document. It's all her. I mean, she's married for 45 years and some assets weren't in her name. Everyone named in the will or the trust had to receive a copy of a notice that said, she gets it. Nobody else got it. It's all hers.
Well,
everybody had to be notified.
We had a situation where the person said, my A friends get 50,000, my B friends get 25, my C friends get 10. And so when she got through, after attending the workshop series, she came up to me afterwards. She said, will everybody know if they're an A, B, or a C? And I said, yes. She immediately went out and changed her trust.
But, then again, you've passed and they may hate you, but you're not here anymore.
Yeah. And
it's your money. It's your estate as long as you're alive.
Yeah. And she didn't mean it she just knew the A people better than she knew the B people and the C people. She was actually being very kind, but
she's giving gifts. God.
Yeah, exactly. But she didn't like everybody knowing what everybody else got.
So, Pete, I wanted to also bring up, another thing you can't do if you take on, let's say, the office of trustee. You can't just come up to me and say, hey, Trevor, I'm trustee, but I want you to do everything. And then still occupy that office. There are certain things that you can't, delegate out. And you have to assume all the responsibility and liability.
And that's paying the creditors.
Yeah, that's paying the creditors and everything that you do. But
You
this
know,
is
what
an
I see mostly in families is number 5.
Yeah. Number 5, where the trustee conceals the act of the agent. Yeah,
Yeah,
because I've hired this person, he messed up. How do we cover this up? Yeah.
yeah.
No, I know. That's exactly something. I mean, and when you're hiring people, there's a code here that really talks about the liability of improperly delegating, what you're not supposed to do. You can't direct the act of certain things that you've hired them to do. Um,
Most of the time we are hired by beneficiaries who are litigating. And so we come in as the neutral third party and say, okay, everybody back into their corners, and then we handle the estate. As professional fiduciaries, it's the odd that we're named in the document right off the front. Most of the time, our work involves the court system. So we're kind of like the bad cops on the street. We have to maintain that the majority of people, there are no problems. Yes, Don.
I know under intestate rules, a child isn't a child unless they're either legally adopted or biological child, so stepkids don't count. Here's the opposite issue. There was a child, but the child was adopted out.
It depends on what the trust states.
no, not if it's a legal adoption.
It's a legal adoption. I'm assuming they're out of the family. Okay.
By
that would be my
intestate
assumption.
rules, but you could still benefit them
Oh,
if
yeah.
you want.
you could name them in, yes.
Yeah.
But if someone's
Exactly.
going to go do let's do a family, let's do 23andMe and discover this other bloodline.
Yeah.
If they legally were adopted out, then they are not legally in the family.
No, it's
Yeah.
not. They don't go by blood in that
Right.
sense. If there's been a
Okay.
legal transfer.
Okay.
And that's a lot of times in the beginning of the trust, they give a little bit of the family history. And it's it gives everybody an idea as to what they think the family is.
Yeah. So just to wrap up, the trustee has a duty not to delegate to others the performance of act that the trustee can reasonably be required personally to perform. Okay. Now, but there's things you can, like you can hire a bookkeeper if you're not, good at that. You're obviously going to hire a CPA to do the tax returns. If there's rental properties in the trust, you probably have a property manager that does everything, above board.
How many tax returns upon death will the person have to file?
I just got through that. I'm still in trauma. No, I'm kidding. I thought you were going to ask like how much my office files. It's like 25, 30 for other people. But on the year of death, okay, you're definitely going to file your 2 state and federal 1040 returns up until the date of death, and then if you have a trust or an estate, you're going to file your 1041 and your 541s from your date of death till the end of the year. If you are a high net worth individual and you're above the state tax exemption, you may also have to file what's called a 706. If there's also a probate estate because you've left assets, you're going to have to file another tax return for that estate. So you could file up to 6.
If you have an A, B, or C trust, you would have to file a tax return for each one of those trusts.
Yeah, so you could be getting up to over 5, 6, 7 trust return. Tax returns a year, and that's why you got to keep things separate and identified and good records. And gosh,
Yeah. And you got to hire the good professionals. So many a times you hire the CPA who does fiduciary tax returns. You don't hire the person that just did your income tax return that has never done a fiduciary tax return.
Or you don't TurboTax your fiduciary tax
No.
returns.
You don't want to hire an estate planning attorney who doesn't do trust administration.
Exactly. Yeah, that's true, Pete. Or especially if you an attorney that's not even in the field of trust.
This is a great slide to hire a family member.
Yeah. So family members, remember, we know most of you are doing this, and these are just good qualities that Pete and I have come up with that I think from our experience are good qualities. So first of all, do they have the time? How busy are they? Are they a CEO of a company? Yeah. Are they the CEO of the company? Do they have the family of their own that they're dealing with?
Are they living out of state?
Yeah. So proximity is also, are they nearby? Do they have their
Desire.
Yeah,
You missed desire. I mean,
well, because you said out of state, so I jumped to
but desire. Have you ever been all of a sudden get a call and say you've been named in a document and nobody's ever told you?
It happened on the same day last week, Monday.
Yeah. So
Two of them.
people name people, even family members, and they never talk to them.
No, I think they think they're going to put an indentured servitude contract on them. But
Well,
no.
a lot of times within families, they think that they'll hurt somebody's feelings if they're not named.
No, I know and that's really the wrong reasons to make a decision on something as important.
Yeah. So desire is really important because the person that you want to pick, maybe they know something a little bit more about the dynamics in the family that they just don't want to serve.
Exactly. Yeah. No, and the thing is I think when you talk to your successor trustee and sort of gauge that desire, go through a lot of the duties that we talked about earlier and see if they really want the job.
This is such an emotional decision.
Yeah.
People do not sit down with these qualities and go, okay, check. They have the time.
And
check.
not everyone has all of these perfectly. There's going to be, you can't expect it. So you kind of do your best.
Yeah.
Just giving you qualities that make sense. So organization, that's so important regarding record keeping and even if they're, we talked about if someone's going to pay themselves for their time, writing down what you've done along the way so you can kind of keep track of your time. That's also an organized task that I think comes into play that is very important if they're, can do something like that.
Yeah. Some people just don't want to delegate. So the ability to delegate is really important.
Yeah.
And communication. I mean, during that 120-day notice period, there's a lot of pillow talk. What do we mean by pillow talk?
Oh, it's a legal term in the probate code that talks about the in-laws asking one of the beneficiaries, hey, when's the money coming? We haven't heard from your brother in a while. I wonder what he's doing with all that, whatever. So it's called pillow talk.
Yeah. So you got to communicate even when nothing is going on, because when nothing is going on, everybody assumes something is going wrong.
Yeah.
Presence. What do you mean by presence?
Well, Pete, what I mean by that is, when they walk into a room, what is their presence? Are they a bully? Do they come in and tell everyone what to do, or are they a wallflower? Do they just sort of go along like, oh, whatever you guys want? It's fine. But what kind of presence do they have? And a lot of times you use the point that mom's in the hospital. She had a stroke or something. All the kids descend into the hospital room, and that if they're a bully, it really is a wrong. I don't know. It's just not a very good presence to have as a trustee.
And transparent. What does that mean?
Well, this particular job is all about trust, and you have to have no BS involved in regards to the transparency of how things are going, and that includes not only your communication, what's going on, but also with your accountings and all the financial information. You really just have to tell them what it is and not hide things. That's what I mean.
When you start hiding things, that's when people get very suspicious as to what you're doing. By the way, these qualities, even if you hire a professional, even if you hire a friend, these are the qualities to look at. Because even though we have a license, that doesn't mean just because we have a license that somebody understands all these qualities.
Yeah. And if let's say you're not organized, very organized, but you'd be so good at, all the other things, you can delegate, prudently monitor a bookkeeper or somebody to help you with that side of things. But to just, not do that and then be unorganized is actually way worse than spending a little money to pay someone to help you do that.
Don, how much time do we have left?
It's on there.
Less than you want. 7 minutes.
Well, we're
Okay.
at
Oh,
the
that
end
was
of
the end. I'm sorry. I just said note to you, so I don't know how many more slides. So 7 minutes.
I mean,
Oh, good. Good.
there's yeah. So do you want to share the things to do when someone dies slide?
Yeah, I think it just to show somebody that that it's on our website and that you can go to, that's the fiduciary with things to do. They're not in any immediate order, but
We always seem to add some.
yeah, yeah, it's
That's easy
kind of, I would print it out, and if you named a family member, hand it to them and say, these are the things that you more than likely will have to do.
Yeah, or go through them and cross out what doesn't apply.
Yeah. Yeah, it's but it's and it's a process, and it's a lot of times people don't understand how much time is involved. They've been trained that, okay, we're not going through probate. That means that I have a living trust. That means I get the money within 2 to 3 months. Not true. I've had living trusts where it's taken 6 to 7 years. I've had trusts that have taken 6 months. So it depends on the family. It depends on the assets in the trust. How liquid are you? If the property needs, the most important asset in most of our estates and trusts is our home. Well, what happens a lot of times when we get a little older and get to be in our 90s, we're not spending as much on maintenance. So the key question is, how much do we put into the home before we put it on the market?
Yeah, that's a big problem. And gosh, that's a whole nother presentation almost. But there's a lot of real estate issues in trust administration, and trying to be that Prince Charming that comes in and fixes up the kitchen.
And isn't it typical that you charge an extra fee when you're having to manage that?
Yeah, because you would.
It's more time for you.
It takes longer to get the property.
And there's no cookie cutter.
Yeah, it always costs more than you thought it would. Therefore, it erodes into people's things, and then
everybody has a different opinion on value, a different opinion of what to do as far as the house is concerned. Everybody's taste is a little bit different.
Yeah.
Let me get off the real estate for just a moment. First thing is that to-do list that Trevor just showed is on the website.
Correct.
It's with all of the other documents that are in there. So it's one of the articles, if you will, that was in there. So that's the same site as all the others. It's the same website that
our fee schedule, our
fee schedule,
form.
all of those kinds of things.
Yeah.
And you pointed it out, Pete, early on, this is not a scare session. But on the other hand, if you have a really small estate, how do you hire people to do these things or whatever? I mean, who's going to pay the fee for this?
The good news is if you have a small estate, then you don't even have to go through probate. You don't have to go
it's
through
under 185,000 or whatever it is now.
Yeah. So it's a piece of cake.
Just put transfer on death beneficiaries.
Excellent.
Yeah.
Very good.
Yeah.
Excellent.
And remember, when you have a small estate, there are usually not that many creditors either. So, and you can always put the burden on the creditor to go after you or after the estate.
Right. Yeah. Yeah. So it's really, I had forgotten about pay on death. There it is. Most of the assets then are going to be transferred out that way.
It's great for small estates.
If the family members are out of state and die, should I be hiring a professional there? Because you're licensed in California. You're not licensed outside of California.
More than likely, there are exceptions. So I've served as a trustee for some folks who are in Idaho, and one is in Nevada. And in those particular circumstances, what I do is I hire a professional fiduciary advisor in that area and have them meet with the client. Then I take the trust decisions locally. That works. But if you have medical issues, if you have real estate, then I would hire somebody locally in that area, because you can't do this from a distance.
So can they send you an email and ask you for, how do they go search for people in Hoopie-Doop?
What I usually recommend is
It's
that,
a legal term, Trevor.
yeah, what I usually recommend is that the trustee is going to have to hire an attorney to represent them. So what I recommend, there's a National Academy of Elder Law Attorneys, and they have an excellent website. And I put in the zip code for wherever the person who needs a trustee in that area. And I asked 2 or 3 of those individuals to recommend a local trustee.
Do you know the name of the trust, the website?
It's NAELA, NAELA.org, but I would just Google National Academy of Elder Law Attorneys.
Okay.
Yeah.
Okay.
Yeah. So Arizona has they have a licensing for individuals there, but only California, Arizona, as far as I know, have specific licensing for.
Yeah, but I would not have a family member do this from out of state, or even sometimes from out of the county, especially during lifetime.
Yeah,
You've
during
got
lifetime,
to.
It's hard.
You can't do this by iPad and fax and Zoom. I'm sorry, it just doesn't. You have to be there.
We often have trusts that are in Orange County that have property out of state or upstate,
right.
and that's manageable. We figure it out, but it's not ideal. We still have to.
There's some issues. Any other questions? We got 9 questions, I see.
Many of them we've been answering. There were a couple that just came in that I haven't read, but
Da, 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 da.
the threshold around small estates. Yes, I think small estates, I think, are like, it was 166,000. I think it went up to 180 something.
Correct.
Property
Title. Remember that, everybody. Know how you have titled assets. Don put a workbook together, which is excellent. Take a look at it. Understand all your assets, label the asset, understand the title, cost basis, market value.
Yeah.
Good stuff to know about your own.
And even if, because there's a separate workbook for both money and estate, download of both. Play with both of them, put them together, because a lot of these things link back and forth together with each other. So basically we've answered them. Thank you very much. Incidentally, a lot of supporting comments were made and really appreciate that. We of course don't enjoy doing this. It's a horrible thing to us. We never laugh at all when we do them. And Trevor's hair is just, woo, he's so excited.
Yeah. It's on fire right now.
Robin Williams and
It's like my
Good Morning Vietnam.
Look, having been in this business, the last comment is that enjoy your money. Okay, it's there for you. You cannot take it with you, and give to the kids. Take care of yourself, and give to others. It's a wonderful thing about life.
So this has been Financial and Estate Literacy. This has been It's Your Estate, Spring 2022. Obviously, we just went through trust administration or estate administration. Review all of these, go back and look at the videos, comments, any other suggestions or thoughts as you go along. We'd appreciate it. Have a good rest of springtime.
I get a lot of questions because they email me. And by people
that's what we like.
No, I know. What's going on in the fall? What's the plan? Are we going back to
since Trevor, since you're a professional at what you do, what do you think COVID's going to be doing in the fall? Then I'll think about it. The answer to the question is we want to be live because clearly doing this on screen is so difficult for us.
No.
The flip side of that is we will probably always have a Zoom version, but if the world is in a wonderful place by the time we get to the fall, we'll be doing them in person, and that's the best of all, because then we can all see each other and pass notes to each other and do whatever we're doing. And the videos, incidentally, I thought you were going to ask how long they stay live. The videos that we have will be at least through till we start doing this again in the fall.
More than likely a year.
Yeah.
A year.
Yeah.
And then, so I think we're scheduled to start mid-September.
I was going to say mid-September is my guess. Yeah.
Yeah. So have a
Enjoy
look
your
after that.
summer, everybody.
Yes. Be safe. Thank you very much. Take care. Bye-bye.
Bye-bye.